Good afternoon, my lord. Hodgson for the Pursuer Hardware and Services Limited. The case calling is for a debate today based on the Pursuer's preliminary plea. In order to explain the case today, can I ask that my lord has the record, the productions, authorities and Rule 22 note. My submission today is that the court should grant the decree de plano as craved for £83,200 plus interest at 8% per annum from the date of citation until payment, and to find the defendants liable for all expenses. Alternatively, if my lord is not with me, I ask that the court set aside the counterclaim and grant decree for the admitted balance by the pursuers plus interest plus expenses. In terms of the counterclaim, set aside, I urge my lord to set a proof before answer so that the counterclaim and issues of remaining balance may be dealt with separately. On this basis, the pursuer's first plea in law should be sustained, that the defender's arguments and answers being irrelevant, subpartium, lacking in specification, the defences here should be repelled, and decree de plano granted as craved. So the defender's first plea of irrelevancy being removed, along with the defender's fifth plea in law, which is the defender being entitled to retain any sum due to the pursuer pending determination of the counterclaim, and the action should be dismissed. To justify my submission, I would like to explain the undisputed facts of the case before us today, the issues between the parties with reference to the defender's counterclaim and the defender's fifth plea in law, which does not amount to a defence in law and not relevant and no relevant case law to substantiate and use relevant case law to substantiate my submissions to you today. The undisputed facts of the case, my lord, are as follows. The defenders, Prime Macadam Limited, ordered 12 separate 95-tonne consignments of road resurfacing materials between the months of over the months of June, September and October. These were to be delivered to multiple places within Scotland. Those are Alloa, Kirkcaldy, Edinburgh and Boswell. This is a case for payment. Today this is a case for payment. The invoices lodged as productions can be found in productions 5/1 through to 7 of process and 5/19 of process to 5/113 of process. It is indicated in the aforementioned invoices that payment will be due within 30 days, and per the invoices, as my lord will see, the amount owed to the pursuers totals to £43,200, and this is the sum sued for. The pursuers carried out all the deliveries with no issues and complied to the British standard quality control measures of temperature and storage, etc. The defenders checked each batch as and when they were delivered and signed a receipt of invoice of conveyance to that effect of the batches being satisfactory. So if we move to the issues between the parties, this is shown in the defendant's counterclaim, my lord. This claim is in respect of the delivery to the defender's Kirkcaldy site. It is here, my lord, that the defenders argue that the materials supplied were substandard and later had to be replaced to the defender's expense. It is on that basis that the defenders are withholding payment to the pursuers pending outcome of their counterclaim. It is here, my lord, that I wish to draw your attention to productions number 5/1/1 through to 5 and 5/19 through to 11 and 13. These are invoices which are all accepted by the defenders as accepted. These invoices are therefore, my lord, these invoices are mentioned in the defenders' pleas 2, 3 and 4 as these and can they be repelled as these deliveries are not in dispute today. The only invoice that contains the material in dispute today is in production 5/1/12, and that is number the number of the invoice is 76543, and that is for £3,600. This debated delivery can also be highlighted in the defender's answer, in answer 2 of the counterclaim and answer 2 of the record. It is the pursuer's position that the defenders are not entitled to, on the basis of legal authority, Barton Distillery Scotland against Barton Brands Limited in 1993, when the principal action is for an illiquid claim and the counterclaim is for a liquid claim and the counterclaim is illiquid, the illiquid claim must be proved. In the Barton case, the whisky suppliers sued for payment and the defenders failed to prove the failure to supply and also failed to prove the market value of the goods in question. Therefore, there were no exceptional circumstances that allowed retention. Decree de plano was granted and proof before answer was allowed in respect of the counterclaim in this case. If applied to the case today, the defender cannot offset the amount in their counterclaim for the sum sued in this action. The principal sum sued for is liquid debt, which is easily seen by the invoices produced. In contrast to this, the sum sued for by the defenders is illiquid, therefore must be proved. The defenders have failed to do this, and therefore, my lord, this cannot be accepted. There are, of course, exceptions to this law, but hopefully I may explain why these exceptions are not relevant to the facts of the case today. Where there is an illiquid claim admitted, both illiquid claim arising via mutual contract where one of the parties are bankrupt, where retention was justifiable on the grounds of convenience. The defence is based on the ruling from Inverspec versus Tullish, Papers 2010, lodged with the productions, my lord. Here it was found that the defenders were in fact entitled to retain the sum sued for in damages pending resolution of the principal sum of the pursuers. This was an appeal case, and this ruling relied on the obligations that arose from one contract. My lord, this is important because it contrasts with the case today, which deals with multiple individual contracts which were dealt with on each individual merits. This can be seen from the invoices lodged today as productions. Therefore, there is no mutuality in terms of contractual obligations, so the defenders cannot rely on this authority as it is inconsistent with today's case. All invoices were separate agreements, and all were required to be paid from 30 days. That time has clearly passed, and crucially had also expired by 2 months when the defenders first had issue with the product in question, and obviously the 2 months is a month overdue from when the payment was due. As per McBride, it states in Part 9, paragraph 2066, the defender's right to retain money must exist at the time when the payment of the price was due to the pursuer. My lord, clearly that is not in harmony with the facts of today's case. This is also shown by Purac Limited against Bizac Limited of 2005, which is also lodged for you today, my lord, whereby 2 companies entered into a contract with a third company. This mirrors today's facts as the issues arise of a retention happening within the contract's stipulated payment time frame. In the authority I'm mentioning, however, the time was 5 days. While in Purac, the defenders, I submit, my lord, the defenders were successful. This was on the basis of exceptional circumstances. Again, this is not in harmony with the facts of today. Therefore, it is the pursuer's submission that the defender's defence does not amount to a defence in law, and to conclude, today I propose on these points that decree of de plano is granted in full in the sum of £43,200 plus interest thereon of 8% per annum until payment, and find the defenders liable for all expenses of preparation and attendance today. If there's anything else I can help my lord with, thank you.